Lawsuit has now been filed against Governor Whitmer after yesterday's protest of her stay-at-home order in Lansing.
The people behind it say the order is an overreach. So our Michael Martin spoke to a constitutional law expert to get his opinion.
Well, we're in the thick of the state-mandated stay-home order now. Bars, restaurants, most retail stores remain closed. Landscapers and greenhouse employees still barred from returning to work. And now a federal lawsuit filed asking the courts to decide if the governor's order goes too far.
Not to make light of the pandemic, it is a terrible thing. But the fact remains that we are seeing a number of issues every day that have constitutional implications.
Several weeks in, concerns over Governor Gretchen Whitmer's extended stay-home order are reaching a sort of boiling point. Thousands attended a rally at the Capitol Wednesday, most of the protesters staying in their vehicles, honking their horns and waving signs.
People are concerned, rightfully so. I'm not minimizing those concerns. And so then, people are willing to do those things that are necessary. But then when you start imposing government restrictions on fundamental liberties, particularly in ways that don't actually make sense, people are starting to get a little angry about this.
Attorney Robert Muse, along with two other plaintiffs, filed a lawsuit this week asking the courts to decide if the governor's order goes too far in limiting personal liberties.
As an attorney and a constitutional lawyer, I'm relying on the courts to help put a brake on what I think are some overreaching on the part of the government.
We have the right to life, liberty, and property. The key word there being liberty. Our Constitution has historically recognized that people have a right to go out, be with others, spend time with their businesses, spend time doing their jobs.
But Professor Schindler says there are times that the government has what he calls a compelling interest to cross those boundaries. And this is likely one of those scenarios.
Now, since that time, the Constitution has changed and our interpretation of the Constitution has changed. And most likely, what's going to happen with these lawsuits is the court is going to apply a thing known as strict scrutiny, which means that any law that interferes with the constitutional rights that I discussed, freedom of assembly, freedom of association, must be narrowly tailored or necessary to achieve a compelling government interest.
And that could be where the lawsuit has some merit, if the courts find certain parts of the order don't fit the end goal.
Preventing the spread of the pandemic, to make sure that we social distance, to sort of flatten the curve. I don't think there's any question that that is a compelling government interest. The issue comes down on how closely tailored the governor's order is to achieving those goals.
And Muse believes that's where the governor has overstepped, saying the order simply goes too far.
And I think the American people would be willing to continue to do that, to engage in social distancing and these other things. But when you've gone so far that now you're infringing on our liberties, that's when, the American people say, enough's enough.
Now, according to online court records, the governor and the two other defendants listed have until May 5th to issue a response to the filing. By that time, of course, the stay-at-home order will likely no longer be in effect. We did reach out to the governor's office. They said we do not comment on pending litigation. For now, though, in Grand Rapids, Michael Martin, Fox 17 News.
Thank you.